Your Honor.
Yes, ma'am.
Okay.
This screen that says district court witness, is that a laptop or what is that?
Yes, sir. I'll turn it on. If you only knew.
If I only knew. Can you adjust that camera? It's going to need to go up.
Yes, sir.
Do we not get our IT problems handled?
We have now. When you said this one, they have it all.
Sure.
Because I cut y'all's heads off all the time.
Up a little bit higher because when Richard gets up there, he's a little bit taller than Mr. Stevens. There we go.
Awesome.
Good afternoon, Mr. Stevens. How are you, sir?
I'm good, Judge. How are you this afternoon?
I'm doing fine.
Yeah. I have Alyssa Villarreal for arraignment.
All right. Ms. Villarreal, if you'll come forward, please. This is cause numbers CR 2280 for arraignment, which is possession of a controlled substance, penalty group 1, less than 1 gram state jail felony. And we are also here on a misdemeanor case, MA possession of controlled substance 2022-30 that was set for pretrial. We'll go ahead and take up the arraignment. Go ahead, Mr. Stevens.
Yes, Your Honor. If it may please the court, my client would advise the court their name spelled correctly. She understands the nature and the consequences of the charges. We will waive reading of the indictment and her plea of not guilty.
All right, the court enters Ms. Villarreal's plea of not guilty into the record. We'll set this matter for pretrial. We'll carry both cases for pretrial on the same docket. Mr. Stevens, do you have your calendar available? Would you look?
Good, Judge, and Patty had said 2/18 might be a good date. I'd like to use that date if possible, Judge.
Okay, that's fine.
Okay.
All right, court sets Ms. Villarreal for pretrial in each case on February 18th at 1:30. Should Ms. Villarreal make bond or bail in her case, then her cases will be on the same date at 9 a.m.
All right, sir. Thank you.
Thanks, sir.
Just a moment.
That's fine. So Patty, what's the issue with the IT?
Everything. I don't know. It wasn't working when we got here. They said it had been working 30 minutes before we got here. McGee was here. And he and Mr. Beaver said they didn't do anything, and then it just started working.
Okay, so are we on the county's IT system right now?
Now we are.
Okay.
We were not to start with, but we are now. Okay, we got 3 out here that did not have attorneys. If you want, we can start with Mr. Penrod. Lucas Penrod.
Did you appoint Mr. Schmidt to all those cases?
Yes, sir, all 3.
Okay.
Flores and Skover.
All right, I'll write those down. All right, Mr. Schmidt, who would you like to go with first?
Harold Morgan.
Say that again.
Harold Morgan.
Mr. Morgan, sir, if you'll come up. This is cause numbers CR 24-105, CR 24-159, State of Texas versus Harold James Morgan Jr. We were set for plea today. Go ahead, Mr. Schmidt.
Judge, we were set for a plea. We've set Mr. Morgan for a plea quite a few times, trying to get it into court based on a plea offer that had been made in my with a lack of communication between myself and the DA's office. The plea offer that we were prepared to proceed on is not the plea offer they believed it to be. So based on that miscommunication, I spoke to Ms. Curry and she relayed to me a different plea offer. I understand the miscommunication. So at this point, we'd ask to set him for a docket call on that February 18th. I'll sit down with Mr. Morgan and discuss the new updated plea offer, which is significantly different. I understand the difference, but it does change the calculus quite a bit. So we'd ask for that February 18th docket date.
Are we ready to set for final docket call so we can have a decision
Yes,
one way or
sir.
the other?
Yes, sir. I think that would be appropriate.
All right, court will set Mr. Morgan then for final docket call on February 18th at 1:30 well, I guess we need to do 9 AM because he's not in custody, correct?
Yes, sir. Yes.
All right, that'll be at 9 AM, Mr. Morgan, and you'll be here in the courthouse at the 294th District Court.
I'd be excused.
Yes,
Yeah, that's my.
Yeah, we'll have to.
Mr. Penrod.
this is cause number CR 24-281, State of Texas versus Lucas Wayne Penrod. For arraignment, the court, having found Mr. Penrod to be indigent, has appointed Mr. Richard Schmidt as attorney for Mr. Penrod. Mr. Schmidt, are you ready for arraignment?
Judge, I received a copy of the indictment, went over that with Mr. Penrod, his name spelled correctly, he understands the charges. We'll waive formal reading and plea not guilty.
Court enters Mr. Penrod's plea of not guilty into the record. It sets this matter for pretrial hearing. Do you want that 18th or something a little later?
I think the 18th should be sufficient, Judge.
All right, court sets Mr. Penrod for pretrial February 18th at 1:30. Should Mr. Penrod make bail, his case will be at 9 AM.
Yes, sir. Sure.
This is cause number CR 22-46, State of Texas versus Melissa Lee Schoonover, and we're set for arraignment.
That's correct, Judge. Same response. We went over the indictment. We'll waive formal reading. Her name is spelled correctly. Enter a plea of not guilty.
All right, the court, having found Ms. Schoonover to be indigent, has appointed the Honorable Richard Schmidt. Court finding that the defendant has waived the formal requirements of arraignment, enters her plea of not guilty into the record, sets this matter for pretrial hearing on February 18th at 1:30. Should she make bail, the hearing will be at 9 AM.
Yes, sir. You got it. Jacob Hall.
Jacob Thomas Hall, CR 24-136,
He said he can't see both people.
and we're set for docket call.
Judge will ask to set Mr. Hall for plea on February 18th.
All right. Court sets Mr. Hall for plea before the court February 18th at 1:30.
Mason.
Who's next?
Oh,
This is cause number CR 24-233 and 234, State versus Mason Edwin Hoover for pretrial. Good.
correct, Judge. I've received the discovery. No contested motion this time. Ask for a docket call.
All right, there being no contested pretrial motion, court sets this matter for docket call on February 18th at 1:30.
Michael Williams.
Cause number CR 24-193, State of Texas versus Michael Scott Williams for docket call.
Judge gonna ask for a final docket call on Mr. Williams. I think we should have him worked out by the time we come back.
All right, court sets Mr. Williams for final docket call February 18th at 1:30.
Barney Jones.
We'll ask for a pre-trial. Okay. Cindy Smith,
Files number CR 21-190, State versus Cindy Marie Smith for docket call.
Judge, I'm going to ask for one additional docket call. I'd ask if the court has a docket sooner than the February, sometime in this month.
Got 2 weeks, January 21st.
That works, sir.
All right, court sets Ms. Smith for final docket call. Is that what you said? Final docket call or just another docket call?
Just another. Hopefully, it'll be the final one, but I don't need a label at this point.
Okay. Court will withhold ruling on a label. And
Yes, sir.
that Ms. Smith for docket call January 21st.
Thank you. Ms. Pickron, Stefan. This is
CR 24-28, State versus Stephen Pickron, or Stefan, I'm sorry. It's probably Stefan. Stefan Pickron. Are we doing a plea today on Mr. Pickron?
Yes, sir.
All right. Mr. Pickron, sir, you'll raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
Thank you. You can lower your hand. All right. Is your name Stefan Pickron?
Yes, sir.
And Mr. Pickron, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Did you say no?
No, sir.
Okay. And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and understand the answers to all of your legal questions?
Yes, sir.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
All right. And Mr. Schmidt, do you believe Mr. Pickron to be competent today?
I do.
And you've explained to him his rights as they pertain to this case?
Yes, sir.
And in this plea agreement, do you believe he's entering into this intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Pickron, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 with an amount between 4 grams to 200 grams. That is a second-degree felony that does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. I see that the proposed plea agreement in your case is upon your plea of guilt. The state is recommending that the court consider the evidence, and if it finds enough evidence to convict you, that it not convict you today, but rather place you on 4 years of deferred community supervision.
Sorry, Judge. I don't mean to interrupt the court. That was the original judgment. We had needed correction. It's the judgment that I have in my hand that is the correct judgment is that upon a plea of guilt that he be sentenced to 5 years, Texas Department of Criminal Justice Institution Division, 180 restitution, DPS lab, and 1245 DA 2023 771 and 770, and he has 291 days credit. So the terms of the plea bargain and the days credit were corrected.
Oh, they have been corrected?
Yes, sir, in the judgment I have.
Okay, so there's no deferred, and it's 5 to do. Because I guess the first paper I said deferred, but then it said punishment at 4 years in prison.
Yeah, that judgment was incorrect.
Okay. All right, let me correct that. So it's 5. So it's 5 to do, 0 fine, 180 restitution, 120. What's the I have reimbursement fees. Do you have reimbursement fees?
I have 120 on reimbursement fee.
290 on court costs.
Yeah.
And you said 291 days credit.
Yes, sir.
And then 1245, and I think those are right. I see those in here. 2 possession cases that are unfiled from the DA's office.
Correct.
Okay. So, Mr. Hartwell, can you get that judgment corrected for us?
And I know Ms. Abney has already corrected it. and sent
Oh,
us,
yes.
she has sent us the corrected copy.
All right, so you have the corrected copy already.
Yes, sir, I do.
Okay, all right, so it's just, okay. All right, so Mr. Pickron, let me back up, okay? Since there are some changes that I wasn't aware of. So I've explained to you the range of punishment and the charge, and it appears that the plea agreement is upon your plea of guilty, the state's recommending that the court consider the evidence. And if there's enough evidence to convict you, that the court does convict you today and assesses your sentence at 5 years confinement in prison with $290 in court costs, $180 in restitution, and $120 in reimbursement fees. And towards your sentence, you would receive credit of 291 days for the time that you've already spent in jail on this cause. Is that your understanding of the plea agreement, Mr. Pickron?
Yes, sir. And
Okay.
if you ran concurrent with my sentence.
Yes, sir, you are correct. This judgment here says that it would run concurrently. Now, I don't know what it's running concurrently with, but it says that it would run concurrent, so it's not consecutive to anything.
Okay.
Mr. Schmidt, is there any more specificity as to the concurrent question?
No, sir.
Okay, all right. So, Mr. Pickron, then understanding the plea agreement, understanding the range of punishment, how do you plead to possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams?
Yes.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
Yes, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, court will consider the evidence. All right, the court, having considered the evidence, finds there to be sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement and the recommendation today. Court hereby convicts Stefan Pickron of the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams. Assesses punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay court costs of $290, restitution of $180, and reimbursement fees of $120. Further, the court does dismiss and takes into consideration unfiled possession of a controlled substance cases DA 2023-771, DA 2023-770. And Mr. Pickron is awarded 291 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Pickron, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the officer to be fingerprinted. And good luck to you, sir. Who's next?
Amber Gragson.
All right, this is cause numbers CR 23-182 and CR 23-183, State of Texas versus Amber Elizabeth Gragson. And are we going forward with a plea today, Mr. Schmidt?
Yes, sir.
All right. Before I get in on my statements, let me make sure that I've got the correct plea agreement. Looks like on the second degree possession of controlled substance as indicted, deferred 4 years, $750 fine, $290 court costs, $585 reimbursement, $180 restitution, $1245 of an evading arrest with previous, and intensive as a condition of community supervision.
That's correct.
All right. All right, Ms. Gragson, ma'am, if you will raise your right hand, I will place you under oath. Do you swear, Ms. Gragson, that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. Is your name Amber Elizabeth Gragson?
Yes, sir.
And Ms. Gragson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney. Mr. Richard Schmidt, are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
And do you have any questions before we go further?
No, sir.
Mr. Schmidt, do you believe Ms. Gragson to be competent?
I do.
And you believe that she is entering into this plea intentionally, knowingly, and voluntarily because she understands it?
Yes, sir.
All right, Ms. Gragson, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in Penalty Group 1, greater than 4 grams, less than 200 grams. That does carry a potential range of punishment of not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. I see that the plea agreement in your case and recommendation is that upon your pleading guilty to that crime, the state's recommending that the court consider the evidence but not convict you, and rather to defer adjudication of your guilt and place you on community supervision for a period of 4 years. And as part of that, you would be placed on intensive supervision as a condition. You would also be fined $750, responsible for court costs of $290, reimbursement fees to Van Zandt County in the amount of $585. Is that your understanding? Well, and there's also evading or arrest evading arrest or detention with a previous conviction, which has been indicted, which would be dismissed with your plea in this case. Is that your understanding of the plea agreement?
Yes, sir.
Okay. Understanding all that, Ms. Gragson, how do you plead to possession of a controlled substance in Penalty Group 1 between 4 grams and 200 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anybody threatened you or forced you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will consider the evidence. My only question about the stipulation of evidence is that it doesn't state that Ms. Gragson intentionally or knowingly possessed controlled substance. It just says that she was in a car that she was a passenger in a car that went on a police chase. And when it crashed, she fled and they found methamphetamine in the car on the floorboard between where she was seated and the driver was seated. There may be a judicial confession that says, let me look through the admonishments here to see if there's something that says.
Judicial confession claims that she's pleading guilty or that the facts containing the indictment are.
That's what I thought. That's what I thought. So that'll be sufficient then. Okay. All right. Court, having considered the evidence, finds that there is enough evidence to convict the defendant. The court will follow the plea agreement this day and the recommendation from the DA's office. Court hereby defers a finding of guilt on second-degree felony offense, possession of controlled substance. Court defers finding of guilt and places her on 4 years community supervision. Orders her to pay a $750 fine, $290 court cost, $585 in reimbursement fees, and $180 restitution. Further, the court does dismiss under section 1245 of the Texas Penal Code, cause number CR 23183, evading arrest or detention with a previous conviction. And the court places Ms. Gragson on intensive supervision as a condition of community supervision. Ms. Gragson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted, and then the probation officers will meet with you about what's next.
It's already been arraigned. Oh, Amber.
Mr. Hartwell, I'm sure that you've probably already made a note on your docket, but just in case you hadn't, cause number CR 2438 on the back page, Cynthia Warrington. Mr. Weiner had filed a motion for continuance. Didn't know if you
Yes.
were, okay, the court had granted that. I think I referenced that this morning with Mr. Weiner, and I set that for pretrial on January 21st.
Thank you, sir.
You're welcome.
Your Honor.
Your Honor.
Yes, sir.
Rob, Mr. Flores and Mr. Hegel.
Who'd you like first?
Michael Hegel.
Mr. Hegel, sir, please come forward. This is cause number CR 24-232, State versus Michael Tanner Hegel for pretrial.
We have no contested motions on file at this point, Judge. We'd ask for a docket call setting.
All right, there being no contested pretrial, court will set Mr. Hegel for docket call. Do you want that February 18th date?
That'd be fine, sir.
Court sets Mr. Hegel for February 18th at 1:30.
You go. Mr. Flores.
Cause number CR 20-211, State of Texas versus Stephen Flores. So that we're set on status today.
Judge, it's my understanding from talking to Ms. Abraham that Mr. Flores had previously been represented by Debbie Beasley, who's obviously retired. Court's appointing me today to take over. It's a CR 20 case, so I presume there's been some action taken between now and then. I'm gonna have to dig into that, but as of today, what I would ask the court to do is allow me to have a pretrial setting so I could determine what waiver. I think there's been some waivers executed that I need to review, and then hopefully we can get Mr. Flores on.
Mr. Schmidt, just because I don't have my system up and going right now, do you have any of the procedural history on this? Is this open case? Is this a motion to revoke?
I believe.
Your Honor.
Go ahead. Somebody else.
Sorry, I have the case pulled up in front of me, Your Honor. It appears Mr. Flores was set to plead out. Let me see if I can find the date of that. I'm afraid I don't, but he was set to plead and then failed to appear at that plea. So it appears that this was just an open pending case since that time, which would have, here it is, May 27th of 2021.
No waivers of jury trial or anything of that nature?
I do see a waiver of jury trial that was executed as part of the plea. The plea is checked off. It is signed by State Miss Beasley and Mr. Flores, dated March 11th of 2021. So we can definitely make sure that Mr. Schmidt gets all of that in discovery as well.
Okay. All right, court will set Mr. Flores then for pretrial hearing February 18th at 1:30. And if the state will just make sure that Mr. Schmidt has access to discovery, then we'll pick up on Mr. Flores's case.
Yes, Your Honor. I'll work on that now. Thank you, sir.
Thank you, Mr. Harwell.
Yes,
Mr. Schmidt, is that all you have today, sir?
I believe it's it, so.
Thank you for your work today. Do appreciate it.
Yeah, thank you. Have a good day.
Amber, you can let me know.
Ms. Abraham, anything further at the jail?
There, not that I'm aware of.
Sure. Okay. All right. That will conclude the business of the court today, and we are adjourned. Thank you, Mr. Harwell. Thank you, Mr. Hernandez.
Thank you, sir.
Have a good day.
Thank you, sir. Bye-bye.